And we'll now open up our second informational hearing on Kayden's Law and SB 1029 from this year. And we have a number of individuals here that are going to be giving testimony. I assume from looking at the list, some are going to be in person, others are going to be online. And I am not sure at this point who is going to be leading off. So I know Senator Sollman had requested it. She's listed, but I'm not sure if she's up on the screen. I don't see. So let me ask for those who are participating that are supposed to be presenting, did you come up with an order for presentations or?
Yes, Chair Przansky, thank you so much. I'll be leading off, and we have an order for presentations that the presenters are aware of.
All right, Rachel, that sounds great. So for all that will be presenting, please just remember before you start presenting to identify yourself for the record so we can have that T crossed and I dotted. And we look forward to hearing from each and every one of you.
Thank you so much, and thank you to the committee for this opportunity. We are very excited to speak with you about this law and what it means, and I'm going to take very little time. My name is Rachel Schutz. I am the Executive Director of the Family Justice Center in Washington County, and we have a number of speakers about the Keeping Children Safe from Family Violence, or the Kayden's Law Act. That was included in the most recent reauthorization in VAWA, but signed into law by President Biden, and works to ensure child safety measures are adopted in each state. It incentivizes those states to adopt those practices. And so we had worked with Senator Janine Sollman to put forward an opportunity in this long session. It did not move through, and that's perfectly okay, but we are here to give you additional information about Kayden's Law to consider in the next session. So without further ado, I'm going to turn it over to Barry Goldstein, who will be starting off with information about what Kayden's Law is.
Okay, I'm Barry Goldstein. I'm a domestic violence author and expert witness, and I usually work with the research, which is really the problem in the courts. They're not using research that would make it easier to recognize and respond to domestic violence. Most cases they can handle. The problem is a small minority of cases involving domestic violence and child abuse. And they made the original mistake in the 1970s when we had no research. And the assumption was that DV was caused by mental illness or substance abuse. They turned to mental health professionals who are experts in psychology and mental illness, but not domestic violence and child abuse. And so now we have a situation where an unscientific theory that was created to help abusive fathers gain custody from good, safe mothers has more influence over the courts than the two most important studies. One is ACE, ACE, Adverse Childhood Experiences. ACE tells us that children exposed to domestic violence, child abuse, and other traumas will live shorter lives and face a lifetime of health and social problems. And most of the harm is not the immediate physical injuries, it's the fear and stress that abusers cause. And so courts are ruining children's lives because they don't recognize how harmful domestic violence and child abuse is. The other study, the Saunders study, goes to the fact that the courts are using the wrong professionals. We need to use a multidisciplinary approach that includes DV experts. And when they don't do that, they routinely disbelieve true reports of abuse. And so, the purpose of Kayden's Law and other reforms is to force the courts to do what they should be doing on their own, which is updating practices to use the research. In the last 15 years, about 900 children have been murdered. Hundreds of thousands of children never get a chance to have a full life, a successful life, because the courts keep disbelieving true reports of abuse. And that's what we're asking you to change. So I thank you.
Thank you so much, Barry. And I'm going to bring up Veronica next to talk about reunification.
Sorry, I didn't unmute. My name is Veronica York. I do work with Barry Goldstein. He's my business partner. We work as expert witnesses in child custody cases involving domestic violence and child abuse. And Kayden's law is addressing what they call reunification camps. And the fundamental problem in the court system right now with contested custody involving domestic violence is this. They're asking children to just get over it. So that the essence of reunification is focusing on forcing children to spend time with abusers. And courts do have the authority to do that, but they do not have the authority to remove the stress and fear that the ACE research tells us is the most harmful to these children. And so instead of that approach, we really want courts to focus on changing the behavior of the abuser in order for them to have a better relationship with their child in the context of reunification. However, the junk science, and as Barry put it, unscientific alienation theories have a different approach in that they are forcing this relationship and asking children to pretend basically that the past doesn't matter. Now, parental alienation syndrome has a long, torrid past, but for the sake of time, I'll just say that it's not included in the DSM-5, which is a lot of professionals in the alienation industry claim to diagnose parental alienation syndrome. However, there's no research to support it. Therefore, it has been twice rejected to be included in the DSM-5. And the Psychology Board of Oregon, in fact, just disciplined a psychologist who was trying to do just that. So the importance of attorneys and judges having training in these types of matters is imperative. The National Council of Juvenile and Family Court Judges does seek to train other judges about the research that Barry mentioned, ACE and Saunders. Thank you.
Thank you, Veronica. And now we're going to bring up Julie, who is an advocate in Oregon, to talk about the experience that she has seen here.
You're muted.
Sorry about that. Thank you. My name is Julie Bond-Blank. I'm a full-time women's director for a faith-based organization in Oregon that works both the intervention side as far as working with abusers and also the victim side of the programming. I mostly work the victims. I am a certified domestic abuse advocate in the state of Oregon. I'm a DV coach, and I'm considered a DV witness in this arena. I'm also an author and a speaker. And I came here to tell you today of my experience. I'm also a survivor. I did not have to go through the court system. However, in the last 5 years that I have been working full-time in domestic violence, I have talked to over 275 women, 275 women who have had court experiences that are never ever what we would recommend as experts in the DV industry. These are kids getting sent back to parents. These are abusers getting even full custody versus the victim. These are situations where the victim is taken to court time and time again as a manipulation of the abuser. And our court personnel are just not getting it. So that is exactly why here at the organization I worked with, we developed a 40-hour online advocacy training to get people trained. I literally talk to MSWs every day. I talk to counselors. I talk to licensed counselors in the mental health field. I talk to PhDs and I ask them, I said, how much training have you had in domestic violence? And the most common answer I get is we had a 45-minute film and we had a discussion. And that is why I developed the training, because those of us with hundreds of hours in abuse and domestic violence understand the manipulation behind abuse and understand what needs to be done in these circumstances. And our mental health professionals, the majority of them, do not. Some of them are seeking at this point to get more trained, thank goodness. But in the meantime, the court is still pulling people who are not abuse informed to decide and to help with these cases. So as DV experts, we need pulled in on these cases, and Kayden's law would allow for that, would keep our children safer. So I would ask that you listen to the next few speakers with an open heart and an open mind and open ears. These are ladies who have directly experienced these court issues, and we are going to start with Yvette.
Hello, everybody. Thank you for your guys' time. I am very grateful to be part of this special session. My name is Yvette. I'm a community health worker. I'm a victims assistant advocate. I'm a survivor. I'm also part of the National Safe Parents Organization slash coalition, which helped pass Kayden's law at a national and federal level. And I'm also part of the Family Justice Center Washington County's Voices Committee. I'm currently in a family law dispute, and although parental alienation has not come up, I fear that it is because of the trajectory that the evaluator involved in my case and the language that she has used so far has presented. And unfortunately, that puts my son, who is 7 years old, at a huge disadvantage. She cannot advocate for a child that she does not believe after he has disclosed to not only his psychiatrist, but community members, other family members, about what he has experienced in his father's care. And this child at 7 years old has experienced these things since he was 2, 3 years old. And he is now at the point where he has expressed suicidal ideations, harming himself, running away, if he does not have a voice in these courts. And unfortunately, the best interest of the child policy has failed him because nobody wants to hear what he has to say. And I'm afraid of my son's life being put in a body bag because the courts are not trained to hear their voices and respect what they have to say, and in fact are re-traumatizing them and us safe parents by invalidating what we're saying and our advocacy and what they're experiencing. And that's what the evaluator is doing to him now. And unfortunately, the previous judge that oversaw our case made it no secret. He said it on the record in multiple cases outside of mine that he had no experience in family law. He had no education in family law. And unfortunately, I'm not the only one whose lives he has affected. And so I'm now at the point where not only does advocacy matter to me, but even with the implementation of this law, by the time it goes into effect, if it were to pass, it is not going to help me in my case now because I'm due to go to court in a couple of weeks. And my son is relying on me to help him do the best that I can with the community who's helping me. But if not for us, I'm doing what I can to help other children in his position and other families who are also struggling to advocate for their children and for themselves. And as a survivor and as a victim, I fear and I feel for everybody else who also is in the same situation and is asking for these pleas.
Thank you so much, Yvette. We're going to move to Vanessa.
Good afternoon. My name is Vanessa Cornwell, and I am a victim of domestic violence. I just have I have some experiences that I want to share that I think that having Kayden's law in place would have helped me specifically, knowing that I have 3 young girls at home, my children. Back in October of 2022, a judge denied me a FAPA saying that they did not believe in restraining orders and not being in that situation. He sent me away saying that as well as having, I did also have previous records of applying for FAPAs as well as my husband. So there was some misinformation or contrary information that he was trying to sift through. And in the midst of that, he sent me on my way and said, this needs to be something that you guys figure out, and domestically, this wasn't a place for us. The issue there is that on that FAPA, I felt like it wasn't even read, or maybe more so, it was just not taken as seriously as it could have been, or even understood, knowing that it had said that my husband had kicked my 6-year-old daughter, and we were waiting for DHS to give their determination on what was next. He had threatened to kill me and had physically harmed me in front of the children, all within that 6-month period of when I had filed the FAPA. So that FAPA being denied was pretty traumatic for me, and ended up in more threats to both my children and myself over the course of the next few months. Until then, in March, I also went before a judge requesting another FAPA. Those previous denials did give a slight, I believe, to my request, as the judge started off by just saying right off the bat, you do realize that you and your husband, the Cornwells, have been in front of this court quite a few times in the last 6 months. And, it makes me leery to approve anything that you're requesting. So this puts me right off the bat in a really difficult situation, and questioning myself, like, am I doing something wrong, or just feeling less than and losing some confidence right then and there in front of the judge. So I did have reports of DHS as well, reviewing my husband for neglect in this situation, as well as potential abuse towards my 3 young children. As well as additional, more threatening verbal remarks that he had made to me for my life as well as my well-being. And then going along with that, my children are always in my care, and he has told many times that he is not mentally capable of taking care of them. And yet the judge then went ahead and assigned my husband temporary parenting time with overnights, again, which was really hard to swallow. I did get awarded the FAPA, but again, with those difficult slights and pieces that made it really hard for me to keep my children safe. So those are the 2 main events that I wanted to share with the court today.
Thank you so much, Vanessa. Next, we're going to call Ann up. Ann, you're muted.
There. Can you hear me now?
Yes.
Hi. My story is a little bit different, but not. I'm a grandparent. Our grandson has been in family court for 8 years. He's 14. We've spent our entire retirement in family court in a county we don't live in. We can't get the case transferred to where we live. We've been denied all the way to the Supreme Court. I have so much to say that I almost didn't testify. Just to let you know, this is overwhelming to chunk this down. So I'm only going to talk about the last 2 hearings, 2 high points that occurred. Last January, we had a court hearing in which the child's attorney requested that the judge strike from the record a letter to the child's attorney and a summary of significant abuse disclosures written by an expert witness who is a psychologist in child sexual abuse, published author, many, many years of experience. And the judge agreed and ordered that this history of the abuse of the grandchild be stricken from the record. So literally erase the abuse during that hearing. In May, we had another hearing, and during that family court hearing, the judge ordered reunification again. There have been over 24 professionals involved in our family court case. The child is on his 4th attorney. There have been 6 different reunification therapists involved in our case up until now. And of course, we've written the checks for most of it. And the judge also ordered that my husband and I have to buy a $10,000 bond as a penalty for us if we do not force our 14-year-old grandson to visit his parents, whom he has not seen since the last abuse event in February of 2019. So we continue to be punished for protecting. Something has to change here. And thank God we're able to be here for him. He is still being forced to see another mental health therapist he doesn't want to see. He talked to his attorney yesterday. But they can't stop him from seeing the therapist he's choosing to see, because there's a law in Oregon at 14 that you can choose your own mental health therapist. So we're supporting him in that. So this law has to go through. I don't know what has to happen to make this happen, but it has to go through. Children are dying. Children's lives his life is completely compromised. We do everything we can to get him all the healing that we can, but I mean, we're up against it here. Thank goodness we've been able to spend our retirement to do this. But people shouldn't have to do this. What about the kids that don't have grandparents like us? I think it's the most important thing going on in Oregon right now. Thank you.
Thank you.
Thank you so much, Anne. And we're going to call up Lisa.
Can you hear me?
Yes.
Hi, my name is Lisa Swart, and I've been with Voices Set Free. I am currently the executive director of Lotus Island Oasis, which is a trauma recovery center for children in Hawaii. And I also am a trauma-informed paralegal. And prior to that, I was the director of crisis services at Safe Pathways to Safety, which is this Department of State listed it on their website for victims of domestic and sexual assault overseas. So I've worked with a lot of Hague Convention Treaty cases where there are custody disputes and victims of domestic and sexual violence involved. And my experience personally was that I was told that my husband, who threatened to kill my children, would have unsupervised visitation with them. And this is what kind of put me into this whole trajectory of this field of work. I have worked with many, many, many clients who are punished for protecting. If they bring up abuse, they are almost invariably either they lose custody or they are not given even visitation because the courts only believe about 1 out of every 50 cases when they call for abuse. And I've had clients whose children have tried to commit suicide when they've been placed with abusers. One of my coworkers, when I was the director of crisis services, her husband killed both of her children, and the courts had given him custody. And right now in Oregon, there's a misinterpretation. They think that the judges have had training and that they understand domestic abuse, and I can say conclusively that that is absolutely not the case. There are several guardian ad litems who believe the pedophile Richard Gardner's mandate that kids should have to just get over it, and that the mothers should be made to take counseling to deal with their anger at their husbands molesting their children. And that there are judges in Oregon today that is how they rule. And so this law is very, very necessary so that there is a roadmap for these judges to have to follow rather than their own feelings, which are usually inaccurate. So I very, very strongly hope that this can pass, because what's happening is we are forcing children to endure conditions that the Geneva Convention says we can't even force upon prisoners of war. And so that's pretty much my 2 cents for these 2 minutes, and I thank you for your time.
Thank you so much, Lisa. And now we're going to turn it over to Senator Sollman.
Thank you so much. Chair Brzezinski and members of the committee, for the record, I'm Janine Sollman. I'm the state senator for Senate District 15, which includes areas of Forest Grove, Cornelius, Hillsborough, and the Rock Creek area of Washington County. I really want to thank the advocates that are here with me today for sharing their very personal pain very publicly. And I want to thank you for this opportunity to have this discussion today. I had submitted a Kayden's Law bill this session that would have done several things. So the bill that I introduced would have developed a training program focusing on domestic violence and child abuse in family law cases, and would have required specified judges, court staff, and court-appointed professionals to attend such trainings. It would have prescribed minimum experience requirements from expert witnesses that testify in family court proceedings regarding abuse and trauma, and would have prohibited the court in child custody proceedings from ordering certain removals, reunification treatments, or other actions to improve the relationship of the child with one parent over the other. States passing bills compliant with Kayden's Law requirements will be eligible for a minimum of $25 million in federal funds starting in 2023. As a board member of the Family Justice Center of Washington County, I have heard from numerous advocates and survivors that improvements to the family court system are very much needed, and that in order to protect children and survivors of abuse and domestic violence, we must have better training and awareness for judges and court staff. And as a survivor of domestic violence myself, and growing up in a home where violence was a traumatic and constant pattern, I understand this pain and this fear all too well. Again, I thank you for this opportunity, and I thank the panel of advocates that are here today that shared why this law is so very important and needed in Oregon. And I commit to continuing that work and to work with them to advance this issue in policy and practice, and to bring light to create positive change. Thank you.
Thank you. I'm going to open up all of our individuals who gave testimony for questions from the panel or from the committee. So does anyone have any questions? I'd like to make Senator Manning first.
Thank you. I do like to say thank you, Mr. Chair, to all of the advocates that have shared your stories. I hear you, and I understand your pain. I, too, know of people that have been victims of domestic violence, and it seems like there's no out once it happens. It seems like no one wants to stand beside you or even believe you. And as a former police officer, I've seen those instances where people have been actually murdered after years of domestic violence. That's why a lot of legislation that I advocate for is designed to try to protect the rights of victims. And some of that calls for getting guns out of the hands of those abusers. As a former law enforcement, I've seen it, and it's something that is real. I believe everything that you said, because I have seen it with my own eyes. And I offer you my humble gratitude for sharing your story, and whatever I can do to help make a difference in your lives and the victims that are out there that's not here to testify. Rest assured, I'll be there for you. Thank you, Mr. Chair.
All right. Other comments? As the chair, I also want to thank everyone that has presented today. This definitely has given us some focus as to perspectives as to what we need more answers for, and some of that includes as to what is the current training within our circuit court for our judges that are overseeing these type of cases when you have victims/survivors coming in seeking out FAPA orders and others, as to what is actually their bandwidth, meaning the individuals making those decisions. So I am hoping that, I know that there is a representative here from the Judicial Department, that maybe we can get some perspective as to what is currently being provided, whether it's voluntary or mandatory type of trainings, and how we can help facilitate this information getting into the hands of those who are charged and have the duty to make these type of decisions. So, anything else, other comments? Again, thank you very, very much from each and every one of us here at the committee for you to take the time that you have, and as has been stated, for you to be willing to share your personal stories with all of us. We thank you, and we hope that the rest of your day goes well. With that, I'm going to go ahead and close the informational hearing on Kayden's Law.